So in argument we went through points that I've indicated I was going to draw lines. of February. That's the talking at the house. There she's corroborated by Mr. Apollos in his statement. So that's the plan. Insofar as the amount of money is concerned, she's corroborated by Mr. Apollos and Mr. Van Rijn. Also corroborated by Mr. Kutsia. As to the argument that ensued on that day, confirmed by Mr. Apollos to Captain Lombard and Ms. Sosa, places it right there. Then, on what happened on the 19th and her presence there, both Mr. Apollos and Mr. Van Rijn, the microwave, and so on. Even that they had to go and collect the money later. The fact that they smoked a quart of mandrax, in the evidence of Captain Colonel Morris, Mr. Van Rijn confirms it in a social media video that was made. The visit to her house on the night of the 19th, where Ayanda got upset. This is confirmed by Gongota and Kobese, totally separate from her. She made mention of that Joshlin was sold. Miss Smith, she says, spoke to her on the 23rd. No counter evidence to that. This whole issue of hers talking about the Sangoma, Mr. Van Rijn was the one that came up with that at another stage. I can point at a number of issues, and it's not exhaustive, because my view is to look at it differently. We refer to the elements of what the state need to prove on the human trafficking charge. The difference between Ms. Lombard and Mr. Van Rijn and Mr. Apollos relate to the memes. She confirms, they corroborate her on the plan. At least Mr. Apollos corroborate her on the plan. But both Mr. Apollos and Van Rijn speaks about the execution of the plan of disposing of Joshlin like a commodity on the 19th. And that was the plan on the 18th, according to her. And we know as a matter of fact that Joshlin went missing. Read all of that in, and then I'm going to turn to all the circumstantial evidence and the conduct of the parties and the fact that no evidence was placed before the court for the defense. So when one analyzes the evidence of Ms. Lombard that was available at the end of the state's case, no credibility findings have been made yet, were evidence of corroboration, because the statements of Mr. Apollos and Mr. Van Rijn were not admissible against Ms. Smith, but they were admissible against themselves. There's evidence on record, and if it corroborates his state's evidence, that implicates Ms. Smith. It can only strengthen the state's case on that evidence. And that was the reason why I refused it, because there was evidence before the court on which a reasonable court could convict. So the following findings are made insofar as the witnesses are concerned. None of the evidence was disputed. They then became proven facts. Insofar as Mr. Coetzee is concerned, I accept his evidence for the reasons I've given, having regard to the cautionary rule as well. Insofar as Ms. Lombard is concerned, I find sufficient corroboration for the reliability of Ms. Lombard from other evidence and the circumstantial evidence. And that is the discussion of the planning for turning Joshlin into a commodity and selling it. It's a matter of fact that she went missing. She indicated that all three, the now accused, were party to this pact with her. She's confirmed in that regard by Mr. Apollos and Mr. Van Rijn. They support her evidence in that regard. Over and above that evidence, now read with Mr. Coetzee's evidence, we've got all the other pieces of the circumstantial evidence at play. And most of them, viewed at independently and individually, might not seem significant. Because when one evaluates circumstantial evidence, you look at the evidence in totality. And it is so that all these small little pieces Miss Swanepoel's example will complete the puzzle. It might also be seen as the little tiles in a mosaic from which you draw inferences. But as discussed in our cases, reported cases, like the ball of feathers that becomes like a millstone around the neck of somebody, it weighs you down. So let's look at the circumstantial evidence. 2018, Joshlin is a baby. Andrews wants to adopt. Build up a relationship between the two families. Parents does not want to agree. Fast forward to the 18th of February the next year. The 18th of February 2024. Mr. Apollos says he was told by Miss Smith the reason for selling Joshlin was because of Miss Andrews doesn't want to stop trying to adopt Joshlin. Circumstantial evidence in that regard. So that little vague tile becomes brighter. Turning to Miss Andrews. Miss Andrews describes the conduct of Miss Smith because she knows her. And she tells us how Miss Smith behaved herself after Joshlin's disappearance. Whilst we're there, let's deal with her conduct. She's inconsistent as to why Joshlin didn't go to school that day. The timeline doesn't make sense. She comes home at 5 or 4:45. On the one version, she was aware that Joshlin was not at home at lunchtime. And why not go look for the child? Then you do. But you find it more appropriate to go and charge your phone instead of looking for the child. Then you tell everybody the child made you famous. Then you go jive and dance on the 3rd of March. And there are many more. This is not the conduct of somebody that's unaware of what happened to the child. They go and sleep that night. I want to say stepfather and mother. Next evening you sleep like a baby at Kelly Seeger's house. And so it goes on. Similarly, Mr. Apollos, Joshlin was left in his care. Also, inconsistent versions. Hiding Mr. Van Rijn away, not mentioning Mr. Van Rijn there, does not partake in the search. He's been told by Miss Smith, stop the tram, show some emotion. It's uncontested. Why is it necessary? So what I have is that the conduct of particularly Mr. Apollos and Miss Smith is not that of a concerned parent. And why not? To my mind, the only inference is because you knew. And that supports in itself Miss Lombard and coming from Mr. Apollos as well. It's not the end of the case. Because all of that was before the court that I've just summarized at the end of the state's case. I confirmed with all three the persons. They chose to remain silent. You have a right to remain silent. As the Constitutional Court pointed out in State versus Busk, it's not absolute. There comes a time where the evidence is such that it calls out for an answer. And yes, you may still exercise your right, but it has risks, because the court can draw an inference. And the inference I draw is, why not come and answer? You've heard the evidence. Why not come and tell me they're lying? But your conduct was such from day one, not of the trial, from the 19th of February last year. There's no real interest. You don't go and search. You don't do what common sense asks us to do. So let's turn to the whether on these facts I can make a factual finding of what happened to Joshlin. Was she delivered to the white polo? Was she delivered to Makalima's house? As from Mr. Apollos and Mr. Van Rijn. Because of the different versions that Miss Lombard gave, I cannot find a warrant of reliability for the white polo. So that's not proof beyond a reasonable doubt on that score, because of the cautionary rule. But is it necessary to find how the means, how Joshlin was delivered? I've already made a finding as to how the law should be interpreted by saying that it's not necessary, but it can be inferred, because you have the plan, you have the purpose, commodify, hand over, and it's a matter of fact. Does that satisfy the requirements of the charge? So, on the main count, I have already found that on the evidence before me, Joshlin was exchanged. The fact is that her freedom of movement and liberty was inhibited. Now that in itself are the main elements, the act of kidnapping. Kidnapping is mentioned as one of the means in subsection G of section 4.1. But also, the evidence is from all schools. There were payments, or at least the promise of payments. Also, if one looks at the overriding subsection J of the Act, it refers to the purpose that it includes all forms of slavery or practices similar to slavery. And the definition section of the Act defines slavery as reducing a person by any means to a state of submitting to the control of another person, as if that person, that other person, were the owner of that person. So by treating a human being, in this case a child, as a commodity that can be sold, it falls within that definition. I've already commented by looking at what the Act is for kidnapping when I determined whether it falls under the subsection 4.1 contravention. It's clearly that act of depriving Joshlin of freedom of movement and liberty to the extent that the whereabouts is still unknown is unlawful. So that will satisfy the elements of the offense on count 2. Now before I make a pronouncement, I also have to deal with the indemnity of Ms. Lombard. I have decided not to deal with that application or my determination of it now. They will clearly be clear from what I've said so far that there will be another stage in this case. And one doesn't know what more evidence might be presented at that stage that might influence that decision. Furthermore, in the event that I have doubt on that question after all the evidence in the case has been laid, I might consider wanting to grant Ms. Lombard's legal representative to address me on the issue before final determination is made. But the primary reason is that I foresee a possibility that evidence might still be laid in the next phase of this case that might impact that decision. So for the reasons that I have stated, I'm of the view that the state succeeded in proving the guilt of Mr. Apollos, Mr. Van Rijn, Ms. Smith on the main count in count 1. and on count two. So the following order is issued. You may remain seated. On count one, you are guilty of a contravention of section 4.1 of the Act, read with the other legislation on trafficking in persons in relation to Joshlin Smith. On count two, you are also convicted of kidnapping. Can I just ask the public, please just bear with us. I know that's emotional, and I understand the expression of your emotions. Let us complete our process that we need to do for now. Then I'm going to adjourn. Then you can express your emotions as you wish. There you go. 60 hands. Certainly. Mr. Policy must listen.
On the 27th of October 2020, is a conviction of theft committed on the 22nd of August 2020. The sentence imposed was a fine of 1,000 rand and 10,000 rand or 10 months imprisonment, which was very suspended for 3 years on condition not again convicted of theft or attempted theft. And there was also a declaration that he is unfit to possess a firearm. That is the only conviction against accused number 1.
Mr. Paulus, do you admit the previous conviction? Good. You will be given the form to sign. And I'm not sure whether, do you have a fingerprint pad here? You can do the fingerprint later, warrant officer. Just leave it there, so leave it by yourself.
On the 3rd of October 2014, convicted of 2 counts of robbery, which was committed on the 17th of March 2014. The 2 counts were taken together for purposes of sentence and 24 months imprisonment, which was wholly suspended for a period of 3 years, on condition that it was not again convicted of robbery or attempted robbery being committed within that period. And there was 12 months correctional supervision imposed, and he was also declared unfit to possess a firearm. The next conviction is on the 17th of January 2016, also for robbery, committed on the 23rd of October 2016, and there he was, the sentence was 2 years imprisonment. And then the next previous conviction is on the 28th of March 2018. That was a contravention of section 4B of Act 140 of 1992, positional 8th of December 2022. There was, however, an extra endorsement where it was readmitted. The endorsement date was the 28th of October 2021 to serve the remaining portion of the sentence, 407 days imprisonment due to a violation of the parole supervision conditions. Those are the previous convictions of Mr. Van Ryn.
Mr. Van Ryn, do you admit to your previous convictions? Thank you. So whilst the administrative tasks have been performed by the constable, we now need to plan. So I'll tell you what my prima facie view is. We should maybe postpone the matter to a holding date, which will be a date, say, not this coming week, the week thereafter in Cape Town. I will deal with it early in the morning. And by that date, we will then determine whether you're going to lead evidence in aggravation. I suspect so. Whether the defense wants to call any witnesses in mitigation. Then we'll know how many witnesses we need to call. I hope nobody's going to ask me for correctional supervision report because it's not applicable. No, I'm talking about to the defense already. I'm talking about correctional supervision, but we also don't know whether there are any other assessments to be done. So once we know that, we will have an idea how long it will take to compile everything, but also how long we will need for the sentencing proceedings. And then I would want to come back here, because I think it's as fair that we do it here. But all the prep work we can do whilst being Cape Town, it'll also give me the opportunity to, I thought I might still have to go to the office in town today. I was supposed to be in Cape Town today, in the office. But I'll see what I can arrange. So that's just my idea. How do you feel about that from the state side?
That sounds good. The state doesn't need to need some evidence, at least we can impact statements or definitely be prepared. If the defense, if I might just ask, if the defense could perhaps indicate that they want to...
I'll hear now. Mr. Harmsen. Will you be able to, next week Friday, will you be able to advise me by next week Friday? In other words, I can postpone the matter till Friday next week, which is the 9th of May. I doubt that I have appeals, but we will have a courtroom available, so I can do it in one of the courtrooms there. That's just for everybody to report back. This is what we want to do, so that we can start planning from there. And then we can say we do it at 9 o'clock. All right. Ms. Nkabai. Yeah. Mr. Sivnarayan, similar? Alright, so what I'm going to do is, it's 10 to 1. Right? I'm going to clearly, they must be transported to Polsma. It's going to be difficult now if I issue the order now for Polsma. So I'm inclined to do 2 warrants, 2 detention warrants. To authorize both places, and as I say, at this place and or that place, so that maybe tonight they can be held closer so that they don't have to take the R27 on a Friday in the middle of a long weekend. Otherwise, the police will only reach Polsmoor when tonight. And they're going to hit the peak hour traffic on their way to Kai. So I'll hear from Warrant if I say Malmesbury, and then during the course of the week they can make arrangements for them to be transferred. Okay. And will it be Langebaan for Ms. Smith for tonight? That'll just it'll just make it easier, because I can foresee problems if it's too late. Also, we're not sure what time they're going to leave from here now to wherever they need to go, because there's a lot of admin to be done. I'm also aware that because we made the arrangements the other day, that their parents might be here. I'm not going to make an order. It's not my place. But often what I do is, if I convict somebody, and if it's possible, I tell the court orderlies, if it's within your powers, I won't have a problem if you at least have their family speak to them before you take them away. Right? But I'm not going to make an order because I don't know what the arrangements are. So the following is going to happen. Mr. Van Rijn, Mr. Apollos, I'm going to do your warrant dual, so it will be Malmesbury, Polsmoor. Ms. Smith, I'm going to do you Langebaan, Polsmoor. You will be appearing at the High Court in Cape Town on Friday. All that will happen there is I will be informed how we're going to do the process further. And it will depend on availability of witnesses, reports, and so on. And once I have that, if we determine a date, we can postpone the matter back here for a day or 2. It won't take longer than 3 days, I take it, to come and finalize the matter, where I will then have to impose sentence. I want you to give your legal representatives instructions as to what you want to do, because remember, there is a prescribed sentence of life imprisonment on count 1. Just remember that, so that you don't sit back and it's your choice, but so that I have everything before me, and I know the state is going to argue for life imprisonment. So just give your instructions. Members of the public, can you just remain calm now? I'm going to adjourn. Then give the police an opportunity to take Mr. Apollos van Rijn and Ms. Smith out of the courtroom to the holding area. And then you can quietly leave, or if you then want to clap and ululate or whatever, that's your business. Right? I'm not going to stop you, but let's give them the opportunity to do their work. And then we leave orderly. Remember, we're a big number of people in this hall. Let's leave orderly, and thank you for coming. The court letter.